Good morning or good afternoon, depending on where you are connecting from, and welcome to our webinar on the protection of intellectual property in China and Southeast Asia. The webinar has been organized by the China and Southeast Asia IPR SME Help Desks in partnership with the Yildiz Technopark and the Yildiz Technopark Technology Transfer Office. Before we start, I would like to quickly introduce myself. My name is Leonardo Mosca, and I work for the China IPR SME Help Desk as a project executive, and I will be moderating your session today on behalf as well of the Southeast Asia IPR SME Help Desk. For any questions regarding the webinar, the services of the help desks, or the protection of IP in these regions, please do not hesitate to send an email to the address you see on the slides. Just so you know, all the slides will be available online from tomorrow. You will receive a follow-up email around tomorrow noon with all the links to download the PowerPoint presentation and the video recording of today's session. So don't worry if you miss any details or if you would like to replay any parts of the webinar. So you will receive all the details tomorrow. A technical comment. So you will see on the right-hand side of your screen that there is an interaction panel that you can use, of course, to adjust your audio settings, but also, and most importantly, to interact with the speakers. So please do not hesitate to type in any questions you have for our panelists today, or for myself, if you have, for example, any technical issue with the webinar, feel free to use it as you want. And all the questions, of course, for our speakers will be addressed at the end of the session during our question and answers session, which will be around 10-15 minutes. So before I leave the floor to our speakers, I'm going to introduce very quickly the services of the help desk. So basically, the China and Southeast Asia IPR SME help desks are two of the help desks funded by the European Commission in support of European SMEs interested in exporting their products abroad. The service, of course, provides free assistance not only to European companies, but also to Turkish companies because it's funded by the COSME program, and Turkey is part of the COSME countries of the European Commission. So basically, the aim of these initiatives is to protect and to help companies protect their intellectual property in China for the China PRC Help Desk, or in the 8 countries covered by the Southeast Asia IPR SME Help Desk. There are other 2 help desks funded by the European Commission, which cover Latin America and the European market. So you will find more information on our website, and I included the URL on the last slide of the session. So basically, how do we support companies in their internationalization and protection of IP? The most direct assistance that we have is through our inquiry helpline, which is an email address where you can send any information, any question regarding the protection of your intellectual property in those regions. And our IP expert will reply within 3 working days, free of charge and confidentially. Also, we organize training workshops, webinars like today in partnership with other intermediary associations, technology transfer offices, chambers of commerce, clusters, and so on, to train companies on specific topics related to IP protection in those regions. Also, on our website and blog, you can find the latest news, business guides, fact sheets, infographic, e-learning modules, case studies, and all the information that companies need to adopt a successful strategy when protecting intellectual property abroad. So now, without further ado, I would like to welcome the panelists for today's session. We are very happy to have with us Ms. Pinar Mendes from the Yildiz Technopark Technology Transfer Office as patent and licensing specialist. Good afternoon, Ms. Pinar. Since you're based in Turkey, it's already afternoon there. And if you could confirm that you can hear me and your microphone works well.
Yes. Yes, good
Great.
afternoon, Mr. Mosca. Thank you. Thank you for introducing me.
You're welcome. And also a warm welcome to Mr. Simon Chidham, the IP expert for today's session and team leader of the China IPRSM Help Desk. Good morning, Simon. Let's check it. Yes, I think there might be, yes. Simon, can you hear us?
I can hear you well, thank you. And yes, hello to everybody too from me.
Great, good morning. Before leaving the floor to Ms. Pinar, I wanted to go quickly through the program of today's session. So after my brief introduction on the webinar and the services of the help desk, Ms. Pinar will provide an overview of the Yildiz Technopark. And after that, Mr. Simon will address the protection of intellectual property in China and Southeast Asia. To end, of course, with a Q&A session of around 10 minutes where we can address all the questions we receive from the audience. So, Pinar, the floor is yours. Let me know if you want, when you want me to move ahead with the slides.
Thank you again, Mr. Mosca. Yildiz Technical University started its activities of opening technology development zone within the frame of entrepreneurial university model of 21st centuries and established the Yildiz Technopark in 2003. Yildiz Technopark continued to grow in line with the principle of sustainable development at Davutpaşa campus since 2009. And İkitelli campus started its operations at the end of 2014. Next slide, please. Within two campuses, 12 buildings, and 148,000 square meter office space, Yildiz Technopark hosts 490 R&D companies, 140 incubation companies, and 60 academic spin-off companies. It has 1,850 successfully completed projects, 50 approved patents, and 370 pending patents. Yildiz Technopark has 8,500 qualified R&D employees in various sectors, such as software development, machinery and manufacturing, electronics, information and communication tech, pharmaceuticals, chemistry, aerospace, energy, defense industry, construction, medical, and food. When we have looked in terms of percentage to the technology areas of the companies, we see that 71% composes of software development, 60% is electronics, 5% is information and communication tech, 4% is machinery and manufacturing, and the rest of the percentage composes of the other areas of technology. Thanks to the completed projects, Yildiz Technopark created 2 billion Turkish lira revenue in last year. Next slide, please. For the purpose of transferring the knowledge created in university to industry, Yildiz Technology Transfer Office generates IP policy and offers training and consulting services to academics, students, industrialists, and entrepreneurs in the issues of developing R&D projects, protecting intellectual property rights, incorporation and commercialization of business. To this end, Yildiz Technology Transfer Office has different departments, consist of IP management, project support, university and industry collaboration, corporate communications, entrepreneurship and incubation center. Next slide, please. With the purpose of taking part during the whole process of protection of IP rights, we make the required effort to create awareness and support all licensing and commercialization process. On the other hand, we are seeking to partner with industry or other organization for effective intellectual property management and knowledge transfer. Next slide, please. As Patent and Licensing Department, after receiving the declaration of inventions and conducting the novelty and commercial reports over the patent databases, all inventions are being evaluated by the Industry Property Evaluation Committee. which consists of the academic members of Yıldız Technical University. The committee may decide to the ownership of the evaluated invention or to relinquish the invention to the inventor. The inventions which are decided to be held by the university are filed before the related patent office. With this stage, we aim to protect the inventions which have novelty and commercial potential for being licensed in the future. Therefore, we are developing the abilities which will serve to the ecosystem of industrial property, and as improving and using these abilities, gaining incomes for the purpose of getting long-term maintainability. Next slide, please. In November 20th of 2019, we have licensed one of the university's pending patents related with dental composites to one of the well-known companies in the related sector. With this invention, it's aimed to produce the dental composite filler in the amount of $5 million value. In this manner, the import rate of the dental composite fillers in the amount of $30 million will be decreased, and the product will contribute to the R&D activities. And that's all. Thank you for listening. I'm leaving the floor again to Mr. Mosca. Thank you.
Thank you. Thank you very much, Ms. Pinar. Again, I would like to remind the audience that all the slides will be available from tomorrow on our website, and you will receive the link via email. And as well, if you have any questions for Ms. Pinar, please feel free to type it in the question log on the interaction panel that you see on the right-hand side of the screen. So moving forward, we can now enter the core of the webinar with the presentation by our IP expert, Simon Cheatham. A quick introduction of Simon. He's the team leader of the China IPR SME Help Desk and also the external expert of the Southeast Asia IPR SME Help Desk. He has over 30 years experience in commercial investigations, due diligence, and IPR enforcement in China and internationally. And Mr. Cheatham is as well the managing director and founder of the law firm Arinias International. So Simon, again, welcome. And before leaving the floor to you, I would like to engage a little bit with our participants today and launch this poll to see if any participants today have already registered their IP in China or Southeast Asia, or if they are interested in any of these markets. So now you will see a pop-up window, and please feel free to select any answer that you wish. I'm gonna launch the survey shortly. Okay. Yes, so I'm just reading the question again. The question reads, have you registered your IP in China and or Southeast Asia? And then you have 4 different options. You have yes in both markets, only in China, only in Southeast Asia, or not yet, but planning to. I will give around 30 seconds for the replies, and then we can close the poll and leave the floor to Simon. Okay, we see that 44% of the participants have casted their vote. Let's wait another 10 seconds. Okay, I'm gonna close the poll shortly. Yes, okay, let's share the results. Simon, if you want to comment on the results, we see that 83% haven't registered yet their IP, but planning to, and 17% only in China.
Well, thank you, Leonardo. Yes, that's an interesting result, and in some ways it's very encouraging. And the reason I say it's encouraging is because one of the primary objectives of the help desks is to try to reach businesses ideally even before they start doing business in Southeast Asia and China. So here we have a great opportunity to discuss some of the relevant issues even before participants have been able to do some business there. So that's indeed encouraging.
Okay, thanks. And now I will hand over the control to you. Let me just quickly, yes.
Okay.
Okay, yes, we now see the slides.
Right, so I'll just put on full screen.
Perfect.
Okay, so everybody can see that clearly. Good. Right, well, thank you. Welcome again to today's webinar. I have put up the first slide, which is the agenda. So my aim today is for us to cover these topics. Initially, we'll talk a little about the current scene in Southeast Asia and China, and touch upon the lead up to the pandemic. There have been so many changes happening in these regions in the past months that it's worth reflecting on some of those. We also thought it would be helpful to tell you about some of the measures to get restarted in terms of intellectual property rights in Southeast Asia and China, before going on to talk about the various choices for technology transfer from an intellectual property rights perspective, and to discuss the types of technology transfer before focusing a little more closely on technology transfer via licensing. And then we'll discuss a bit about finding the right business and hopefully avoiding some of the pitfalls, and wrap up with some takeaway tips. But before talking about the scene in Southeast Asia and China and the lead up to the pandemic, I wanted to explain the basis for making some of the observations to follow. In part, of course, it's based on personal experience working in Southeast Asia and China, and that includes meeting with law enforcement and other IP practitioners, but it's also based on inquiries received by the help desks. So the next two slides give a general indication of the type of IP issues businesses are seeking help on in these regions. These charts are based on inquiries to the help desks in 2019. So here you can see a pie chart showing the different types of IP issues that have been the focus of the inquiries received at the Southeast Asia help desk. The biggest category was trademark issues, and that was followed by invention patents, and general IP strategy questions was also a common issue raised. So in addition to the analysis from these different inquiries received at the help desks, we are also able to draw upon input from a panel of experts who work with both help desks. In Southeast Asia, we have external experts who contribute on a regular basis to developments and information in that region, which again assists the help desk to bring the latest information and advice to SMEs. Turning to an overview of rights issues in China, again, trademark issues accounted for the most inquiries at the help desk, and this was followed by general IP strategy questions, and those queries on copyright and patent were also relatively common too. The China Help Desk also has an external panel of experts who contribute information and updates on developments in China. So this gives us some basis for making comments and suggestions about IP issues in Southeast Asia and China. So if we move on to take a look at the situation in these two regions, one thing I think we can say straight away is that you can't look at one market in isolation. Goods and information flow quickly from country to country. And in Southeast Asia, there is the ASEAN Free Trade Area, known by the letters AFTA, and this is a trade bloc agreement by the Association of Southeast Asian Nations, which supports local trade and manufacturing in all the ASEAN countries. It actually stands as one of the largest and most important free trade areas in the world. So if, for example, you sell your brand of products or services in one country, you need to be prepared in case competitors jump in and register something similar in a next door country. China is the largest exporter in the world. China's highest value export products include mobile computing devices such as tablets and laptop computers, as well as cell phones and smartphones and computer processors and controllers and liquid crystal display panels. There's a free trade agreement between China and the ASEAN nations, which has been in effect for a decade. It came into force in January 2010, and that created the world's third largest free trade area in terms of nominal GDP. But China has also established, amongst others, free trade agreements with countries like Australia, Chile, Costa Rica, Korea, Peru, New Zealand, Singapore. And there are other free trade agreements currently under negotiation. For example, with the Gulf Cooperation Council, with Japan, and with Norway and Sri Lanka. The countries in Southeast Asia represent a mix of legal systems. Some, like Singapore and Malaysia, have foundations in common law, and some, like Indonesia, Thailand, and Philippines, follow civil law jurisdictions. The Southeast Asia nations have formed an action plan aimed at transforming the whole region into an innovative and competitive one via the use of intellectual property. The area has no community trademark or regional patent, and it has no plans to introduce this. So for IP rights holders, that means you need to register separately in every country in which you need some protection. Also, it is wise to consider individual trade secret and copyright laws, as it is possible to record these at a national level in some countries. Let's now take a look at what was going on in Southeast Asia and China in the months before the pandemic. As I mentioned, this has actually been a time of significant change, and the overall trend is one of progress. And here are some examples. Singapore, for example, has one of the most efficient and comprehensive intellectual property rights protection regimes in Asia. And as Singapore moves closer to its goal of becoming a global IP hub in terms of IP transactions and management, quality IP filings and intellectual property dispute resolution, the laws governing intellectual property infringements become stricter and more robust. The procedures are also generally swifter than those in neighboring Southeast Asia countries, and it has a transparent legal system and efficient courts. I should also mention that the EU-Singapore Free Trade Agreement will come into force in November 2021. And in recent years, Singapore's law landscape has gone through some changes in preparation for this agreement. In Malaysia, Malaysia has recently introduced the Trademark Act in 2019, and that repeals and replaces the old Trademarks Act from 1976. And there's also the fact that Malaysia has become the 106th member of the Madrid Protocol with effect from December 2019. In the Philippines, there have been no major changes to IP law, but there are special IPR courts, and specialized judges there have at least a solid understanding of IPR related issues. However, actions filed before the courts or before the IP courts in the Philippines still take time to be decided because of postponements or the unavailability of judges, or more recently because of the pandemic. So a case can take time to reach a decision at a trial court level. In Thailand, Thailand has substantially improved both the protection and enforcement of intellectual property rights. And in Brunei, a reorganization of the intellectual property offices took place in 2019. So now the Brunei Intellectual Property Office is under the umbrella of the Attorney General's chambers. So all IP matters are now dealt with under one body. Vietnam is going through some important changes regarding its intellectual property legislation. Also on the 30th of June 2019, the European Union and Vietnam signed the EU-Vietnam Free Trade Agreement. And this agreement was approved by the EU Parliament in February 2020. And this will require the Vietnamese intellectual property law to be amended. I should mention that the Hague Agreement took effect in Vietnam at the end of December 2019, which allowed Hague system users to designate Vietnam in an international design application. And in the past 3 years, Cambodia has enacted many new laws and implemented new policies. But despite being a member of the World Trade Organization's agreement on trade-related aspects of intellectual property rights, that's TRIPS, Cambodia is still listed as a least developed country. So it has until July 2021 to comply with the TRIPS agreement with some limited exceptions. And also until then to comply with the key criteria of the Berne Convention, which is the international agreement dealing with the protection of literary and artistic works and the rights of their authors. So this is of special importance for the protection of copyright. So this is what has been happening around Southeast Asia immediately prior to the pandemic. Turning to China, we've been discussing the changes being made to the IP laws in Southeast Asia and in China, in fact, which is leading to a steady upgrading of IPR regimes. But the two main factors which seem to be driving this change are accession to trade agreements, particularly the World Trade Organization, TRIPS, to enhance growth through trade, but also a recognition that innovation is key to increasing value, which is another key component of growth. And innovation can only flourish under an effective IPR regime. I think you can find examples of this in most countries, but China makes a good case study. As you see on the slide, in 2006, China set a goal to establish an innovative country. And this was followed by a national IP strategy in 2008. And that strategy is leading the whole country, both at a central level and a local level, to put much more emphasis on intellectual property. In fact, intellectual property is now an important part of China's national development. China's strategy was contained in a report called the National Medium and Long-Term Plan for the Development of Science and Technology, known generally in the West as the MLP, the Medium and Long-Term Plan, which is guiding China's development through 2020. And the focus was on employing China's fast-growing domestic and powerful regulatory regime to decrease reliance on foreign technology and develop indigenous technologies that will enable China to solve its environmental and infrastructure problems, and thereby enhance both its economy and national security. Indigenous innovation to China is really seen as enhancing original innovation through co-innovation and re-innovation based on the assimilation of imported technologies. the plan warns against blindly importing foreign technology without plans to transform it into Chinese technology. And in fact, the report states, I'm quoting from it, one should be clearly aware that the importation of technologies without emphasizing the assimilation, absorption, and re-innovation is bound to weaken the nation's indigenous research and development capacity. So what does all that mean? Well, I'll give you an example, a brief example from one sector, and that's in the wind turbine sector. Back in 2004, foreign wind turbines had a 75% market share in China. So China refocused its efforts on foreign technology transfers, and China's domestic wind energy industry took off with the help of a set of major policy developments. In 2005, all wind turbines in China were required to have at least 70% domestic content. The 2006 Renewable Energy Law dramatically increased government money for wind energy projects, and dozens of companies sprang up in China. But to upgrade domestic capabilities, foreign involvement in the manufacturing of wind turbines over 1.5 megawatts was restricted to joint ventures or partnerships. By 2009, the three largest China domestic players, which were Sinovel, Goldwind, and Dongfang, alone had a 60% share of the market, and the foreign share was down to 14%. The Chinese government in late 2009 removed the 70% content requirement for wind turbines after complaints from foreign governments, but by then it was only a symbolic move. Domestic players can now independently manufacture, and they own the market for 1.5 megawatt wind turbines, and that's the mainstream size installed on today's wind farms. And to see where that has led, Chinese wind investment rose about 4% to approximately $18 billion in the first half of 2018. And currently, there is the Made in China 2025 strategy, which, amongst other things, promotes specialization in high-end shipbuilding and offshore engineering equipment manufacturing. But taking a look at some of the specific IP changes in China leading up to the pandemic, as you can see, many changes have taken place. This really stems from the restructuring of the intellectual property registration, management, and enforcement government bodies in China, which was announced in China's two-session meeting in March 2018. This resulted in merging together with the State Intellectual Property Office and the China Trademark Office under the China National Intellectual Property Administration, or known as the CNIPA. So they've brought these disparate functions together, and overall the result seems beneficial. You've got more resources to handle and enforce IP cases, basically as registration and enforcement will be handled by the one entity. Also, we're expecting a more institutional approach from the unification of Chinese governing bodies dealing with IPR. But more recently, we have the revision of the Chinese patent examination guidelines with yet another set of major amendments, including on the examination of inventiveness. In February 2020, the CNIPA published new amendments on patent examination guidelines for computer-related inventions that also have an impact on AI-intensive technologies. And the new guidelines state that for a technical solution, that the AI technology must have a technical effect performed by the AI computer program in order to comply with the non-obviousness patentability requirement. And then in January this year, 2020, the US-China Phase 1 trade agreement was signed. And this included notable agreements on patents, mostly related to the pharmaceutical sector, that might have an effect on all patent applications if China modifies its patent regulations accordingly. Worth mentioning are trade secrets. The protection of trade secrets was strengthened through the amendment of two major laws. The first, the Foreign Investment Law, which came into effect in January 2020. And this required that the administrative organs and their functionaries must keep confidential the trade secrets of foreign funded enterprises they have learned about in the course of performing their duties. And this, of course, is particularly useful for foreign companies that necessarily have to reveal some trade secrets in order to obtain the approval of an authority to import, export, or sell their products. But it remains to be seen how it will be implemented. And I should mention there are still many administrative proceedings relating to business transactions on, for example, product imports, technology transfer, and joint ventures and so forth, where foreign parties are required to provide know-how and trade secrets in order to obtain approvals. These regulations are generally hidden in many sectorial laws, and administrative discretion simply adds to the risk of IP being mishandled. So we're still waiting to see the full impact of this. There's also the anti-unfair competition law, which introduces a couple of major changes with regards to trade secrets too. One is the transfer of the burden of proof, so that now the infringer has to prove that the trade secret claimed by the right holder is not a trade secret. And so that is certainly going to make it easier to get legal relief. And this is reinforced by the Second Amendment, which increases substantially the compensation in case of a trade secret infringement to renminbi 5 million, which is around 640 to 650,000 euros. So quite a substantial fine. So far, there haven't been enough trade secret infringement court cases to analyze the application of these new laws, but some of our experts have noted that judges tend to make different decisions in different locations, with Jiangsu and Shanghai demonstrating generally more experience and consistency when hearing trade secret cases. Just briefly mention geographical indications. Again, the US-China Phase 1 agreement stipulates that China must assure full transparency and procedural fairness with respect to the protection of GIs. And with respect to trademarks, in November 2019, the amended trademark law came into force. Overall, the aim of the amendments in the law was to tackle bad faith trademark registrations and to increase the punishment for trademark infringements. The anti-unfair competition law, which came into force in April 2019, also introduced some amendments to protect brands. And this, for example, includes confusing acts to unauthorized use of the domain name, a website name, or website to enable the trademark owner to stop infringement and claim some damages based on unfair competition and not just based on trademark claims. But despite these recent improvements, trademark squatting, the term used to describe bad faith registrations, remains a pretty huge problem. And in practice, at least for now, it's unlikely that CNIPA will be able to stop all the illicit filings during examination proceedings. So while right holders have more grounds to recover stolen marks, it's still necessary to proactively oppose and invalidate bad faith registrations. So this has been a fairly broad brush summary of some examples of the changes in the lead up to the pandemics, both in Southeast Asia and China, which you can tell have been numerous and quite comprehensive. If we move on now to take a look at what's currently going on in these regions to get intellectual property issues back on track following the pandemic. I think we're all well aware that COVID-19 virus meant a lockdown affecting China and Southeast Asia in order to try and reduce the spread of the virus. So the quarantine affected not only private companies, but obviously many governmental offices. And this caused a series of new and unexpected issues ranging from the economic and financial difficulties that companies continue to face, and which could, in a worst case scenario, lead to a reduction in intellectual property protection, to the challenges posed by large-scale work from home working arrangements that necessitates new ways of protecting intellectual property, particularly perhaps for trade secret protection. The coronavirus outbreak has also presented challenges such as the suspension of the IP registration procedures for a time in the national IP offices. But thankfully I can say that in nearly all cases, efforts are showing good results to reopen and resume activities in most IP offices around the region. So as you can see there, Brunei's Intellectual Property Office has basically resumed working at least half days during the week. Cambodia has expanded its e-filing of trademarks in response to the virus. And the Department of Intellectual Property Rights has implemented new functions in its e-filing system to allow for online submission of most post-registration matters. In Indonesia, generally speaking, the Intellectual Property Office employees are now working at home. In Laos, the National Task Force Committee for COVID-19 Prevention and Control has issued a number of recommendations to generally ease preventative measures and to resume business. In Malaysia, the Malaysian IP office has announced some limited opening of its customer service counter at its headquarters and branches from mid-June. Myanmar government offices and departments are currently working at a 50% manpower level. And in the Philippines, we've seen the Intellectual Property Office there resume limited regular operations at its main office for some time now, over a month. And in Singapore, the Singapore IP office, while it has remained closed, the online portal and its mobile apps continue to be available, and there's quite a lot that can be done online in Singapore. In Thailand, the Thai office is allowing submission requests for extensions of time for filing applications and other submissions due to the virus outbreak. And in Vietnam, there's been a new notice on loosening the strict social distancing measures. And this has meant that the IP Vietnam office has resumed receiving applications directly at its office in Hanoi and branch offices in Ho Chi Minh and Da Nang, and has been doing so for some time. And I should just add that there's a temporary 50% discount effective until the 31st of December 2020 on certain industrial property fees at the Intellectual Property Vietnam office, such as filing applications, extension of time limits, issuing registration certificates, and so forth. In China, the Chinese government responded with a program called 10 Measures to Support the Resumption of Work and Production. But regarding intellectual property, there are essentially 5 main principles to take into consideration. And those are the promotion of online services, simplification and streamline of regular procedures, as you can see, the immediate address of urgent issues, reduction of costs and burdens, and provision of technical assistance and support. To give an example, immediately address urgent issues, the CNIPA decided to give priority to trademark and patent registration to those companies that shifted their production to emergency supplies, like such as masks and protective suits, or producing drugs for the epidemic prevention and control. They've also opened a fast-track system to streamline the application and registration of patents and trademarks involved in new business projects for those companies that are trying to resume work and production. And lastly, I just mentioned that there's been complementary financial support offered to help the most innovative companies that are struggling to get back to full production. In the policies adopted by the CNIPA, there's no mention whether only Chinese businesses can benefit from these policies. There's no precedent that I'm aware of financial assistance being given to foreign companies, but presumably a foreign business with offices in China that's in the process of resuming normal work activities might be able to request to be included in one of the financial benefit schemes. So moving on, now that we see that there's generally activity throughout China and Southeast Asia in terms of IP registrations, to perhaps take a closer look at the issue surrounding technology transfer. Aside from copyright, intellectual property is generally territorial, so that means it must be registered accordingly. So you need to file for patents, designs, and trademarks in each separate country. Now, for some businesses, this may mean that you have to prioritize your key markets first. For example, your manufacturing base and countries where you are currently distributing and selling into, to cover the costs of registering your intellectual property. But care should be taken with this strategy. As I mentioned earlier, goods already move relatively freely across borders in Southeast Asia. Given this, if the budget allows, it may be sensible to file your patents, trademarks, and designs in as many countries in the region as possible. IP protection must be at the forefront of all SME strategies when looking to invest in Southeast Asia and China in relation to technology transfer. In short, it can't be done early enough. A solid filing strategy, whether you are a medium or small business, should be the first step when investing in the region. So if you have not already drawn up a list of your intellectual property, then this must be done. It's essential that you identify your trademarks, your designs, inventions, copyright works, domain names, websites, and trade secrets. And we'd also strongly advise that you obtain legal advice from an experienced IP lawyer to assist in the identification of your IP. Not all IP can be registered, and local laws will and do vary. If a country is a member of the Paris Convention, then it will be possible to register trademarks, patents, and designs. However, it may also be possible to register copyright and record or register trade secrets in certain jurisdictions. In regard to trademarks, you may also wish to consider registering local language marks, particularly if such marks are going to be in use in each separate Southeast Asian country and in China. Taking a look at patents more closely, a patent is an exclusive right granted for the protection of new inventions, which are products or processes offering new technical solutions or providing new ways of doing something. The product or process in question has to be applicable in industry. And in order to qualify for patent protection, inventors or owners must file a patent application, as registration is a requirement in order to obtain protection for a patent. Patent protection lasts for a limited period. In the jurisdictions we are looking at, 20 years. And in return for this legal monopoly of limited duration, the owner of a patent must disclose the invention to the public. A patent is a territorial right and has its effects only within the national boundaries of the country for which it is granted. In Cambodia, Indonesia, Laos, Malaysia, and the Philippines, Thailand, and Vietnam, inventions can also be protected by simple patents. Depending on the Southeast Asia country in question, the name may differ. Petty patents in Laos, for example, utility models in the Philippines and Cambodia, or utility innovations in Malaysia, or utility solution patents in Vietnam. And in China, they are utility patents. These simple patents typically cover products and tools and rarely are used for technologies. These inventions should be novel and industrially applicable. And in some cases, there are no requirements for an inventive step, for example, in Indonesia, Philippines, Thailand, and Vietnam. And in others, the degree of innovation required is much less with a simple patent, for example, in Malaysia and Laos. The process for obtaining a simple patent is generally shorter than in the case of standard patents. But there is, of course, a reduced term of protection, on average 10 years from the filing date. And as you can see from the table, which outlines the period of protection for different types of patents in China and Southeast Asian countries. So just to re-emphasize, patents are territorial rights granted under national patent laws. The patent application process varies from country to country, and we don't have time to go into the specific details, but the help desk can provide this information if needed. But there are, of course, various multilateral agreements that attempt to provide harmonization within the patent system. The most comprehensive is the trade-related aspects of IPR, TRIPS agreement, which requires member states provide for product and process patents in all fields of technology and a minimum patent term of 20 years. But flexibility in deciding own standards of patentability in each individual jurisdiction. Invention patented in one country may not necessarily be patentable in another, even under TRIPS. But aside from TRIPS, there are two other key international agreements that create harmonization with them within the patent system. One is the Patent Cooperation Treaty, and this would facilitate speeding up the patent application process. The Patent Cooperation Treaty makes it possible to seek patent protection for an invention simultaneously in several countries by filing a single international patent application instead of filing several national applications. But there is also the Patent Prosecution Highway, and this is an initiative between certain intellectual property offices which allows an acceleration of the examination of a patent application in one intellectual property office where an examination work has already been conducted in another intellectual property office. And lastly, the ASEAN Patent Examination Cooperation, or ASPEC. And this is a regional patent work sharing program involving 9 of the 10 intellectual property offices in Southeast Asian countries. Myanmar is not yet involved. And the objectives of ASPEC are to reduce complexity, achieve time savings, improve the quality of search and examination. And what happens is that reference is made to an earlier examination already performed in one of the intellectual property offices, which then helps an examiner in the other intellectual property office to better understand the invention claim, reduce searches, and develop a more comprehensive examination strategy. Invention patents are, as probably most of us are well aware, expensive, and it's not feasible to file for these in every case. In some cases, companies rely on trade secret protection or non-competition agreements to protect their innovations or unique know-how. Inventions can be protected as trade secrets if you do not disclose any information on them. So that means keeping them secret. That kind of protection can theoretically last forever, as long as you manage to keep your invention undisclosed. And protection is free of charge, does not require registration, but you have to initiate certain internal steps to maintain confidentiality. And in practice, I have to say, it can be quite difficult for a company to implement measures to keep an invention a secret, particularly when people leave the company and could bring precious know-how or sensitive knowledge with them. It's also important to note that non-competition agreements are not always a viable assurance that information will be kept secret. So while trade secret protection is desirable in theory, if your company is investing heavily into a particular area of technology development and the stakes are high, from a practical angle, it's probably more advantageous to seek patent protection. Another alternative, however, could be disclosing through publication or other means rather than patenting an invention. This could be an option where your business does not require exclusivity. And of course, the advantage of this option is that it blocks others from getting a patent on the same invention. However, it means that any competitor will be free to reproduce the invention and carry out any business with it. Some companies use patent protection as a defensive strategy and assert their patent when an infringement claim is made by a competitor. I should just add on know-how. There is a way to control know-how, but much less control than protectable intellectual property like patents. If you are looking at transferring know-how, this really needs some sophisticated agreements and procedures. As you can imagine, if you are transferring know-how, you as a transferor will want to be paid, and you will not want to transfer the know-how until you have been paid, whereas the transferee will equally not want to pay before being sure of receiving all the information they feel they should get. So that makes the whole issue quite complicated. So there are obviously different ways of carrying out a technology transfer. We are taking a superficial look in this webinar without going into great depth. But I can say that the most common and in some ways the safest between assign, sell, or license is licensing technology. This can be safest for both sides of the technology transfer, that is the transferor and the transferee. Why? Because with licensing, the transferor will keep control of the intellectual property through the contract, which will be ongoing during the cooperation. But if you simply assign or sell the technology, you will lose control. So for that reason, licensing is generally safer in that respect. Of course, it's generally safer to have the continuous help of the transferor for the transferee. So the question arises whether the technology should be transferred on an exclusive or non-exclusive basis. Well, exclusive means only one licensee, but be aware that that does not mean that the licensor may not still use the technology. The exclusivity is on the licensee, it is not on the use. So if you are acting as the receiver or the licensee, and you don't want the licensor to continue to have use of the IP, you not only need an exclusive license, but you should also require an exclusive right of exploitation. I mention this just to emphasize that you need to be very careful when negotiating what type of technology transfer, because there are pitfalls or traps everywhere. Transferring know-how requires different and sophisticated agreements and procedures, as I've mentioned, for the reasons I've outlined. You can, of course, have combined technology transfers, meaning elements of assignment or sale of technology combined with licensing. For example, assigning basic technology, but licensing improvements arising from it. Technology transfer involves taking some risks, whether you are the transferor or the transferee. As the transferor, there are, of course, benefits. You receive cash and a return on investment on your research and development efforts. You may also be able to neutralize competitors by preventing them from developing alternative technologies. It may help you secure or expand the market by providing a uniformed technology offer. It may also give scope to access expertise of a local partner. But there are risks for the transferor. If the transferee becomes, for example, a competitor or improves on the technology, or where inappropriate use may be made of the technology that's been transferred and thereby damage the transferor's reputation, or where the technology is insufficiently mature, or where the transferee involves in some way the transferor's liability. So all these are risks associated with the transferor. If we turn to the transferee, there are benefits and risks on that side of the equation too. The transferee may benefit from the security of using and selling an established technology with some sort of proven track record. And of course, it may give access to new and innovative technology, allowing the transferee to gain a competitive edge, maybe through higher quality products. And this is especially relevant to smaller businesses without in-house research and development departments. Excuse me. It may help expand their customer base and provide a faster entry into the market. But the transferee also faces risks. For example, if the freedom of exploitation of the transferred technology is challenged in the market, or if the technology that's transferred is outdated, or if the transferee pays too much, the cost of transfer is too high, or the accompanying know-how is insufficient. So there are risks and benefits on both sides of the technology transfer equation. Technology transfer via licensing does require careful assessment of all the different aspects. For example, you need to carefully identify the parties to the transfer. And that should involve conducting some sort of preliminary background check, establishing the financial status of the other party, who the shareholders are, the incorporation, documents, conduct court searches, and so forth. It's important to specify details in the transfer process, identify responsibilities and who the key people are, as well as outline the full scope of the technology transfer. So setting out the nature and objectives of the transfer. You should aim to include controls on quality, so that the quality is maintained in the use of the technology that's transferred. The transfer process itself will include costs, the amount, whether it's a payment in a lump sum or royalties or mixed. It will need to spell out the payment terms and the modes of payment as well.
Simon, I'm very sorry to interrupt. I just wanted to say that we're running a bit late, so if you could go through the remaining slides in the next couple of minutes and then address any questions from the audience.
Very good. All right, thank you for that. We are actually a good way through the presentation, so I will move on to just briefly mention an issue that is sometimes either misunderstood or overlooked, and that is just to be aware of the grounds, and by that I refer to intellectual property grounds. That is the background. Background IP is relevant to a collaborative venture or an open innovation project that's supplied from the start of the agreement. But be aware of the other grounds and ensure that they are included in the agreement. You need to have a contract that clearly explains, for example, what the foreground IP is, so that there's no doubt of what you're both bringing to the table. Foreground IP is the IP you'll create together, so you need to state who owns that IP and who gets a license to it, and so on and so forth. Perhaps a good example would be if you're a shoe manufacturer doing a deal with a leading leather manufacturer. The technology related to improving the leather quality would go to the leather manufacturer, and the technology around improving the design should go to the shoe manufacturer. So you want to make sure that these issues are covered in the agreements that you work on. Non-disclosure agreements are very relevant to the whole process. It's sensible to use non-disclosure agreements from the start, even as you are in very early discussion with a potential partner. Try to use non-disclosure agreements to establish your IP protection position from the start. Try to have a non-disclosure agreement already drafted. so that you are well prepared and you have this dealt with in good time. And consider multiple non-disclosure agreements with the various parties that you may talk with partners, employees, possibly even with your own employees. There are various key clauses to include in non-disclosure agreements. Again, we have a guide and can provide separate and additional information on this, but it is important to cover all the different clauses in those agreements. Finding the right partner is, of course, absolutely critical. It's critical from a business point of view. Equally, it is critical to ensure that you're dealing with a legitimate business, and that is why it's so important to take these precautionary measures. Do set about registering your intellectual property before entering into discussions. Try to minimize the technology information release. Put those non-disclosure agreements in place. Have pre-agreements prepared. Do follow up and seek references and carry out a good amount of due diligence on your prospective partner in that respect. And due diligence is so essential that I've put up a separate slide on it. These gives you a non-exhaustive checklist of some of the issues that you should consider checking. You could check company registration records, not only in Southeast Asia, but also in Hong Kong and China. Always ask whether, if you're dealing with a potential partner, whether business payments go to the same company that you are dealing with. Without spending too long, there are certain scams, if you will, where payments for tax reasons or tax evasion reasons are sometimes sent to a different registered entity rather than the business you may be dealing with. And the only other point I'll mention on this slide is carry out an intellectual property check. You do have the capability and you have the right to search on intellectual property in China and in Southeast Asia. You can do searches to determine what patents and what trademarks, for example, have been registered by businesses. And this is very well worth doing. So if you're dealing with a partner that you suddenly discover has registered hundreds of famous, well-known European brands, that will should raise a red flag, and you should question their approach to intellectual property. So this is inexpensive and well worth doing. And again, the help desk can assist with the mechanics of how that can be carried out. And finally, before we move on to the brief takeaway tips, just a brief mention of setting up the right structure for collaboration. Out of these three choices, if you are in a licensing environment, that actually provides less control than you would have if you were to set up a joint venture or a wholly owned foreign enterprise. It's probably fairly self-evident and obvious. Most SMEs will opt for licensing because of it requires far less investment. A joint venture can require more investment, and a wholly owned foreign enterprise requires the most. So licensing depends much more on the contracts and the agreements that you have in place. So do take extra care. For joint ventures, typically they require that a completed product is produced from the joint venture. So you have the challenge of transferring technology to the joint venture while preventing your intellectual property from leaking to other joint venture partners. So you may want to keep critical design work or manufacture of critical components in a separate or wholly owned subsidiary or completely offshore. And for the wholly foreign owned enterprise, the risks are fewer, smaller, gives you the greatest control over a wholly owned subsidiary, but it does mean focusing on preventing IP leakage by employees and business partners. And improvements to transfer technology can often be very valuable. So typically the foreign party will want to own all improvements to the technology made by the local party. So you need to make sure you use confidentiality, non-compete agreements for employees, and include the issues relating to improvement on transfer technology within the arrangements to set up the wholly owned foreign enterprise. So we've very briefly touched upon those. And as we're running out of time, I just leave you with these takeaway tips. While you're just looking at those, just as a cautionary note to end on, and that is that technology transfers do fail in as many as 50% of the cases, and that's generally because of lack of preparation. So one of the takeaway messages should also be prepare, prepare, and prepare. But the only other one I will draw your specific attention to is registry your IP first. If you don't have it registered, it's very difficult to transfer it. So that should clearly be a priority. Right, I apologize for running over a bit, but Leonardo, perhaps I can revert back to you to see if there are any questions arising.
Yes, great. Thank you very much, Simon. I'm gonna take over the control of the slides now. Yes, okay. You should be able to see the full screen. Yes, okay. Thank you very much again, Simon, for the very insightful presentation. Now we can take questions from the audience. Again, also, I welcome you to visit our website for the China and Southeast Asia IPR Help Desk for more information on how to protect your IP in China. But feel free to type in any questions or doubts that you have on what was discussed. And also if you have any questions for Ms. Pinar as well. So addressing the first questions we received, it's more of a comment that you maybe can address. I'm gonna read it out loud for you. So basically, our participants wrote that it seems that China is intent on acquiring foreign technology hook or by crook, and modifications of law are to appease the Western nations regarding the access to market. Moreover, legal cases, whilst they may result in favor of foreign companies, the punishment and fines is often nominal, to say the least. I don't know, Simon, if you have any comments on this remark.
Yes, thank you. Yes, well, I think generally speaking, that's true. But of course, the other side of the coin is that China is a huge market, and it also has, albeit with perhaps insistence and persuasion from other countries, improved and changed its intellectual property regime. It does have significant laws in place, and the Chinese businesses are aware of that. They are very IP savvy, and they make very good use of the local intellectual property laws, and do participate in registering their rights. So you can look at the huge numbers of registrations, for example, of patents, utility models, and trademarks in China over the years, which in a sense have been partly incentivized by the government. But local businesses have made a point of registering as much as they possibly can, understanding that that is a way to leverage income, to leverage more revenue. So the point is that if and when you go to China, you need to do so with your eyes wide open. Understand that obviously, as in fact most countries perhaps do also, there is an interest in innovating and absorbing and assimilating overseas technology and taking a lead in technology. So when you go to the places like China, you need to be aware of that and take necessary steps to minimize the risks that you will face And there are a number of ways in which you can do that, and obviously that would require probably another webinar to go into the details. But there are steps you can take. So go in forearmed and forewarned, and with your eyes wide open. Make use of the IPR regime there, and that is the way to take advantage of those markets.
Okay, thank you very much, Simon, for your reply. We have another question, maybe the last one for today's session, as we're running a bit late. If you could mention the advantages of a WOFI compared to a joint venture concerning access to China, and if it's true that a joint venture will have a better access to the local market.
Well, not necessarily. I think it will depend. For the wholly foreign-owned enterprise, you tend to have the maximum control. The risks related to your intellectual property are less because you exercise the greatest control. If you own the entity that's been set up, it's your subsidiary effectively. So the risks to a wholly foreign-owned enterprise are somewhat different. They're typically risks faced through staffing and the leak of know-how and technology via employees leaving and perhaps setting up in competition. Those are the more frequent types of issues that you face there. Setting up a joint venture, certainly you would have the opportunity then to take advantage of a local partner's contacts or their existing facilities. Or you may be required in any event to set up a joint venture as required by the foreign investment catalogue under certain categories of technology transfer. But the challenges of transferring technology to a joint venture are very real. You need to focus on preventing your intellectual property, as I've said, from leaking to the other partner of the joint venture. And the way to do that is by being creative. You wouldn't want a deal to stop the protection of your intellectual property. So you have to clearly define the roles of both the joint venture and the Chinese joint venture partner or any other joint venture partner. So that's why I've suggested that it's important to try and keep critical design work or the manufacture of components in separate wholly owned subsidiaries or offshore. But you're correct in that the joint venture partner with strong local contacts can give you that access to a sales network, may, for example, be an authorized distributor of the joint venture's products, for example, via the local joint venture partner. Whereas for the wholly foreign-owned enterprise, you are clearly building from scratch, but one would expect that you would be importing some of that capability or knowledge or experience through staffing, through people that you employ to set up the enterprise. So there are certain advantages to joint ventures for sure, and by and large it will give you a faster return. It will be quicker to set up a business and have it operational and effective than it will for having an effective return from a wholly foreign-owned enterprise.
Okay, thank you very much, Simon, again for the answer. Maybe we can move ahead with the final slide and conclude today's webinar. So for any information, update, or to stay abreast of our upcoming events, you can follow us on Twitter, Facebook, LinkedIn. We also have a blog, europinsider.eu, where we post all the news regarding the IP protection in Southeast Asia and China. Or you can go to our website, ipr-hub.eu, where all the international IPR SME help desk are gathered, and then you have to select the market that you're interested in. So there is China, Southeast Asia, and Latin America, which are the 3 help desks. And of course, for any specific question, our inquiry helpline is always at disposal for SMEs. you can send a question to the two addresses that you find on the screen, of course, depending on whether it's for the Southeast Asian market or the Chinese market. Finally, I would like to thank you again, Simon and Pinar, for your very interesting presentation and for taking part in today's webinar. And thank you for all the participants for joining us. And again, you will receive tomorrow an email with all the links to download the PPT, the PDF of the PowerPoint presentation, and the video recording of today's session. Thank you again, Simon and Pinar, and have a nice day.
Thank you, Mr. Leonard, for this opportunity and your hosting. And I would like to thank you to Mr. Simon too. It was very useful to be informed about implementations of the related patent situation in China and Southeast Asia. And hearing about important points of tech transfer is very enlightening for us as being a transfer office. Thank you.
Yes, so thank you for attending and for the opportunity to speak on this topic and for your organization. Thank you, Leonardo.
Thank you again, and I hope to see you next time for our next webinars. Have a nice day.
Have a nice day.